Pakistan. So that was about my introduction. Now I would like to invite our first presenter, Ms. Nuru Sahra. She is to present the paper entitled An Analysis of Issues Tawheed in Light of Decided Cases in Malaysia. This paper is co-authored by Ms. Nuru Sahra and Muhammad Zawawi. Mr. Rakan, I would like to mute you for the time being. Thank you very much. Let's start with the presentation. I think we have just lost Nuru Sahra, and here she's back again.
Hi, I'm back. I'm really sorry, not sure what happened.
You may share your presentation slides.
Okay, sure. Allow me some. Okay. Hi everyone, thank you, Dr. Ariba. Bismillahirrahmanirrahim. Assalamualaikum and a very good afternoon. My name is Nurul Shahira. Together with me, my professor, Professor Rosni Hassan. I am a postgraduate student for Master of Laws in Islamic Banking and Finance. And wait, all right. So my paper today entitled Ta'wid and Analysis of Issues Arise in Light of Recent Cases, where we studied if the decided cases, court cases, to identify what is actually the problems arise in regards to Ta'wid, which is compensation for late payment charge in Malaysia. So first of all, this is my contents that I will be presenting today. Background of research, the statement of problem, research objective, literature review, discussion and findings, research methodology, and conclusion implementations. So first of all, for an introduction, a brief introduction. Basically, Malaysia adopt dual banking systems, the conventional and Islamic banking systems hand in hand. And the Islamic financial institutions in Malaysia are regulated by our Central Bank of Malaysia or Bank Negara Malaysia, BNM, and governed by the Central Bank of Malaysia Act, also the Islamic Financial Services Act 2013. Pursuant to the Central Bank of Malaysia Act, Sharia Advisory Council is established to advise the Islamic financial institutions on Sharia matter and to validate the Islamic banking takaful products to ensure its compliancy to Sharia. So basically, if the Islamic financial institutions compliant to the guidelines and resolutions produced by this Sharia Advisory Council, then they are considered as Sharia compliant. Next is my background of research, is to examine whether the Islamic financial institutions apply resolutions and guidelines of Bank Negara Malaysia in a correct manner. To focus, the focus will be given to the application of late payment charge by the Islamic financial institutions and to determine whether there is any problem in the application. Also to analyze the legal actions brought to court reflecting the current issues faced by the Islamic financial institutions and their customers. For statement of problem, firstly is the inconsistency between the resolutions and guidelines produced by the BNM and its application by the Islamic financial institutions to know that what kind of issues that arise in regards to ta'wid and gharamah, whether that issue will contribute to a bigger problem, such as the ta'wid amount charged will tantamount to riba. And next is our research objective, which firstly to identify whether there are issues arise in regards to the charging of ta'wid and gharamah. Secondly, to examine whether the parties to the financing agreement, especially the Islamic financial institutions, has acquired a full understanding in regards to ta'wid and gharamah. And last but not least, to determine if the issues of ta'wid and gharamah disputed in the court cases are critical and harmful towards the protection of Sharia law. Next is for my our literature and case review for an introductions with reference to Bank Negara Malaysia. Firstly, in 1998, penalty for default in repayment for Islamic financing product was allowed with similar conditions as ta'wid introduced by Bank Negara Malaysia in 2010 and 2012. At this time, it was not referred as ta'wid and gharamah yet. It was just a penalty for default in repayment. And only in 2010, BNM allowed ta'wid, were recognized as income by the seller or financier on the basis that it is imposed as compensation for actual loss incurred, and also gharamah, which means fine and penalty that need to be given to a charity. And in 2012, guidelines for ta'wid and gharamah is established. And the academician has also defined ta'wid as an agreed fine by parties of contract as compensation for the creditor when the customer fails or delay in his obligation to repay the debt. In 2003, a muamalat division at the High Court of Kuala Lumpur has been established. However, this is an initiative to ensure that Islamic banking matters are dealt with by the experts. However, Islamic banking litigator, Hizri Hassan, in his article mentioned that there are still some flaws in the civil court system in dealing with the Islamic finance matter. He stated that this research identifies some structural problem within the civil court system itself, which may affect the proper and effective adjudication of Islamic finance cases. And from the cases that is utilized in this research, the cases are categorized into the identified issues, which is firstly, wrong calculation by ta'wid by the Islamic financial institutions. In Pan Northern Air Services case, the High Court has allowed calculation of ta'wid by Maybank Islamic, but Court of Appeal reversed the decision as the payment was made before maturity date and correct rate to be applied is 1% per annum and not the Islamic interbank money market rate. This is basically has been defined in the ta'wid and in the regulations of Bank Negara, but it is failed to be recognized by these banks. And secondly, in the case of Maybank Islamic Berhad, the respondent has breached the contract and appellant has right to charge ta'wid. In this matter, respondent need to prove his claim that appellant's calculation was wrong. And lastly, in the case of CIMB Islamic Bank, the court also uphold the agreed terms on ta'wid by the contracting parties in the letter of offer. Basically, in this case, it shows that the contracts entered into by the parties are also upheld, but however, the terms of contract must not contradict to the Bank Negara Malaysia guidelines. The next issue is ta'wid charge was inconsistent with the financing agreement. In Bank Muamalat Malaysia Berhad, the learned judge dismissed plaintiff application for summary judgment, and because there is tribal issue where there is no actual calculation by plaintiff in terms of IBRA and terms in agreement not identical to BNM guideline. So, the next issue is whether ta'wid cap at date of winding order. In the Small Medium Enterprise Development Bank Malaysia Berhad, in Section 8(2)(a) of the Bankruptcy Act, applicable to a secured creditor in relation to a winding up, which entitled to charge interest after the date the company is wound up if the secured creditor realized the charged property within 6 months after the date of the winding up order was made. And the next issue is whether the Islamic financial institutions can charge ta'wid. In this case, agreement executed before BNM guideline 1998 and no notification by defendant to plaintiff on charging ta'wid. So the bank charged ta'wid. However, the agreement entered was before the date where the ta'wid was introduced. So 2 experts were called, and they have different views whether plaintiff can claim ta'wid without informing plaintiff. And the learned judge accepted the view which opined that defendant must act fair and just. Plaintiff must make known on ta'wid charge. The court disallowed defendant charging plaintiff on ta'wid, and the Court of Appeal in Pan Northern, the court ruled that defendant must give notice to plaintiff if rate of ta'wid charge is changed. So basically, this also highlight that Islamic banking matters must also value the Islamic the Sharia law and and the moral value that we are trying that Sharia law is trying to uphold. So there are significant reasonings from these cases that we have analyzed. In the case of Maybank Islamic Berhad, the learned Hamid Sultan has mentioned that the learned judge in the previous court should have considered that the unilateral reduction of the banking facility made by the Islamic financial institution has given an adverse impact on the borrower, and the borrower was suffering loss and damages due to the inequitable action of the Islamic financial institutions, and that it is against the Sharia principle. The learned judge has also erred in failing to hold that the action of unilaterally reducing the facility has not followed the equitable principles of the Holy Quran. Next is in the case of Mega First Marketing, the learned High Court judge has mentioned that the courts have consistently taken a disapproving view of customers of Islamic-based facilities who have benefited from the facilities taken and then avoid their payment obligations by raising the issue that the Islamic financing facilities granted are non-Sharia compliant, and the plaintiff are doing in the present case. In this case, we can understand that there are some customers who take for granted on the Islamic banking contracts, where they are trying, whenever their cases are brought to court, they will try to prove that there is non-Sharia compliancy in order to fully strike out the bank's case. And lastly, the study derived that despite the fact that the same law applicable to Islamic banking matters, it is not to be ignored that the soul or values of the Islamic law need also be infused in the decision made by the learned judges in respect of deciding Islamic banking cases. Next is for discussion and findings. So we found that there is space for improvement in understanding on ta'wid and gharamah. Cautious need to be taken in applying the civil law on the Islamic banking matter. Discrepancies may happen in the application of ta'wid when human greed is involved. And in answering the problem of the study, these issues may bring more critical problems such as riba. Our research methodology are basically on quantitative study, where we utilize online database like CIS Advanced Malaysia and CSJ Law. Last but not least, on the conclusion and recommendation, close monitoring is needed because it will directly affect the public, as the amount claimed for ta'wid is distributable to depositors and investors. Ta'wid has to be carefully charged in order to avoid any unwanted elements of riba, and we recommend a future study on the relationship between the miscalculation of ta'wid by the Islamic financial institutions and its exposure to the risk of riba. That's all from me. Thank you. I'm sorry, Dr. Ariba, I can't hear you. I think you need to. Dr. Ariba, I think you need to unmute your mic.
Sorry, that was a very enlightening discussion. Thank you very much. Actually, Pakistan also follows Malaysia, and specifically these two banks, Maybank and CIMB. So the most important thing about your area of study is that whatever decision is delivered in one case, it usually becomes the case law. So all the other cases have to consider that as well, and they have to follow that decision as well. Otherwise, they cannot establish precedents. So I believe that is a very important topic, and the way you have approached it case to case, that is indeed remarkable. Now I would like the audience to ask questions if there are any. Are there any questions, please, or shall we proceed to our next presentation? Okay, the presentation from Islamic University of Bahawalpur has been put on hold since there was an issue with the presenter. So let's move on to presenter number 3. The article is titled The Potential Legal Effects of Central Bank Digital Currency, CBDC, and that is authored by Dr. Hakima Yaqub and Dr. Adli Yaqub. Do we have the presenters with us here? Is there any representative of Dr. Yaqub here to present this paper? All right, maybe not. So let's move on to the next presentation, that is Issues in Islamic Economics and Finance, a literature survey, that is authored by Mr. Murad Yas from Marmara University. Do we have a representative or the presenter himself? Because I cannot see the name in the list. All right, that brings us to the 5th presentation, Artificial Intelligence and its Practical Application to Islamic FinTech, a very interesting topic, and that has been authored by Mr. Marishu Rajabu Marishu and Hakan Aslan. Both are here with us. Mr. Marishu is going to present this, representing Sakarya University. I think Mr. Marishu is having connectivity issues. He has again disconnected. So let's wait for him to join back. In the meantime, I would like to ask Ms. Nuru Saria, is it easy to gather information about all those cases?
Hi. Basically, from our university, we have our own online database which called LexisNexis. So I can say it's pretty like we can access it easily even when we are out of campus. So it's quite easy. I'm not sure how it is in other countries, but I can just type on the keywords needed and they will show the cases.
All the case details. So it has been digitized. The other thing that I wanted to ask was that you have mentioned it's pretty complicated when the laws that are applicable in civil suits, they are also applied to Islamic banking suits. So what is the status of legislation regarding Islamic banking?
As Malaysia does not fully practice Islamic law, so in our courts, it still uses the civil law system, not civil law, the common law systems. So we can say that the judges are highly influenced by the system, and also in regards to contract acts, civil law acts, or other like law that govern our contracts are still the contract acts, which is a common law. And yeah, that's how the both law infuse. Not like we do not fully follow Sharia law in everything. It's just that the fundamentals, and when it comes to court cases, the judges will follow the relevant regulations such as the contract acts.
Okay.
If I may add on that point, Dr. Ariba, that we have a dedicated law on Islamic banking finance, which Shahira did mention, Islamic Financial Services Act. So the court, whenever deciding Islamic banking finance matters, that will be the first legislation that the court will refer to. Of course, other contracts, other law, for example, Contracts Act, land, law relating to land and whatnot is also applicable, because these are how the common law approaches. But in Malaysia, there was an initiative to harmonize the law to be in line or to ensure that the implementation of Islamic banking and finance in the country do not face too much resistance, if you understand me. Means that, of course,
Yeah.
there is a possibility. We cannot avoid that no clash at all. You know, because when talk about different person or different court interpret it differently. But we minimize the risk of the clear contravention between the law on Islamic finance and other applicable law. So this is where the harmonization committee that was established at the central bank level. Okay, so that's why now we find that's very minimal in terms of the clashes. But of course, you know, there are cases as well that still, you know, the court argue, the councils arguing and whatnot. It's normal.
I think it takes time to develop and cover each and every aspect, because they would.
Pakistan could be slightly different because, well, with the new latest judgment on Federal Court of Pakistan as regards to the judgment of riba, I was there in, I think, end of May, and the people are talking about that judgment as well as strategy moving forward, where Pakistan or the country is given 5 years to ensure that, you know, the system should be free from riba.
Yes.
So that could be a big challenge to the country.
Yes, that's right. I think all the countries that are having the dual banking system, that they are having the Islamic banking system and the conventional commercial banks also on the other side. So every country would be facing such difficulties. We are, I think, far behind on legislation. That should be the first thing. Because as I know of Malaysia as well, I have studied a little about the background. So before the products are innovated, there is care taken that there is proper legislation and that the markets are able to receive that product properly. So there's complete planning done by Bank Negara. It has been working and it has dedicated resources for that. For Pakistan, it's a little bit difficult because our state bank, the Central Bank of Pakistan, is having a political appointment at the head of it. So whenever the regime changes, everything else changes. So the government, the courts, and the Islamic financial institutions, they are not on the same page for now. There are quite a few difficulties and issues here.
Yeah, of course, every country have different and unique challenge on this.
Yeah, but the recent judgment is indeed a very good step for development of Islamic finance in the future. So there are good things to be expected in that area. Plus, in Pakistan, the Islamic banks have been very much profitable. Their profitability is probably twice the profitability of conventional commercial banks.
That's great.
So that is also a driving force which has compelled the conventional commercial banks to convert towards Islamic banking. We have our first case here, Faisal Bank, that is now being converted to Islamic banking 100%.
I've heard that 100% of the branches already Islamic now.
Yes. Now they have, in year 2022, they have been working on it and since quite a few years, but now they have achieved that. So that is.
You can see when I was there in Karachi, I can see the good commitment from all stakeholders, central bank, practitioners, and whatnot. Because, you know, and then the case become a push for them to expedite their plan, their strategy. I think that is good. So I believe that in near future, Pakistan will be fully Islamic finance in terms of their practice and law, and can be the model for other countries to follow.
Inshallah, because it's not just the religiosity aspect that is compelling people to ask for Islamic banking options more. It's not just religiosity, it's also that banking in a sense should be just banking. It should be equitable banking. It should have the objectives of Adl and Ihsan. Even if it is a conventional commercial bank, it's not Islamic, it's in whatever country it is operating. It should have the same objectives. I usually ask my banker friends that when did we as people become okay with banking having so much profits? They're charging us such exorbitant profits. We should not be okay with that. We should not be content with the only CSR activities of 1% of the overall profit that are doing as CSR. We should not be content with that. The purpose of banking should be to have a socially equitable society, a good economy.
There's a lot of awareness demand for ethics now. People are talking about ethics, particularly with the MCO. People are more, I would say, more, the feeling is different. Even we reflect our own self, it's a different feeling altogether. And thus, people are more concerned about others. And thus, moving forward, definitely, we're talking about ethics, value that need to be added, not only in commercial, in Islamic, but also in the commercial banking system.
Yes, that's true. I would again like to remind everybody that we are waiting for rest of the presenters who are
I'm
who haven't
just
joined us
chatting, waiting
yet.
while waiting for the presenters. There are other people here, I Haider and Huma. Are they the
Huma is from Islamic University of Bahawalpur, but she's not the author or the presenter. She has been a part of this Karcief initiative since the very beginning. So she's one of the organizers as well.
okay.
And then we have,
Assalamualaikum. Happy to see you, Professor Rashmi. I knew and I read your number of researches. I'm very happy to see you over here and meet you here.
Thank you.
then there's Heather Ali and Tugana as well. I don't know who they represent. So I would just like to read out the names once again if there is anyone who's going to represent these presenters. We have Dr. Hakima Yaqub and Dr. Adli Yaqub, who were going to present the potential legal effects of central bank digital currency. We also scheduled Mr. Murat Yaz at position number 4. He was going to present issues in Islamic economics and finance, a literature survey. And then we had Mr. Hakan, but unfortunately, Mr. Hakan could not join. Mr. Marisho also joined, but he got disconnected quite a few times. So I think they're having problem. They were going to present artificial intelligence in its practical application to Islamic fintech.
And one more thing, Dr. Naila, that was going to present from the Islamia University of Bahawalpur. She thought that session would be started at 8:30 p.m. So just because of this time difference, she could not manage to come here right now. She did not aware of about timing.
Okay. It is a common misperception. That is why we asked for the time conversion, because many of the people in Pakistan, they couldn't understand if it was Turkish time or it was Pakistani time. So that was the confusion basically. I would like to ask the Karcief organizer, what are we supposed to do if the presenters have not joined us? Can somebody please contact them? KTO Karate University, Mr. Sanan. Let me just contact him.
Meanwhile, I would like to talk with Professor Rashmi. Are you here? Can you hear me?
Yes, are you talking to me? Are you addressing it to me?
Yeah, Professor, we want to take your insight about current agribusiness situation.
Sorry?
Can you please share this is not a presentation, just want to know about your, that you are in Islamic finance industry since a long time. What you see about the future of agribusiness? With the
Agribusiness.
will this be acceptable for both Muslims, non-Muslims?
I cannot hear you.
I'm sorry. I think number of participants just join us.
Yeah, that's good.
Let me ask again if any one of them represents the rest of the presenters. I think these are the participants, the audience from the Islamic University of Bahawalpur. So none of them is the presenters that are missing from this session. I have asked KTO Karate University to look and see if they can contact Mr. Hakan or Mr. Mauricio. Dr. Huma, you were asking about agribusiness financing from the
Yes,
Islamic
Dr.
perspective.
Riba, I just had started a conversation with Professor Rashmi about agribusiness situation and its future trends.
Okay.
I think she had left this session.
Yeah, I cannot see her in the list anymore. She may join again. I cannot see her in the list anymore, but she is an excellent resource, especially for Islamic finance. Ms. Noura Saria, is she a teacher of you or are you acquainted by any chance?
Prof. Rosni, you mean?
Yes, yes.
Yes. I am her student.
Okay, same school. Yeah,
Yeah,
that's nice.
It's very nice. I am very honored to be her student.
Yes, mashallah. Dr. Rasni is back with us again. Welcome back, Dr. Rasni. We are asked to wait 5 more minutes by KTO Karate University and see if Mr. Mauricio joins us back. If he does not, then we will conclude the session. The recorded video of this session will also be provided online by KTO Karcief and me as well. All the audience who are here, they can contact me or Dr. Huma if they are from Islamic University of Bahawalpur, or they can contact the KTO Karcief administration to provide them the video for this session.
Meanwhile, I'd like to introduce Islamia University of Bahawalpur, Pakistan to all of participants, including KTO Karate University. Already know about the Islamia University of Bahawalpur, Pakistan, but we want to share with them more information about Islamia University of Bahawalpur, Pakistan if they want. Host, can you listen me right now?
Yes,
KTO
yes.
Karate University. Sinan, are you here? Brother, are you here? I think he is not here.
He's on WhatsApp. He's trying to contact the missing presenter. So he just messaged me that if the missing presenter does not join, then we can conclude the session. Yes, Dr. Uma, you may take this opportunity to introduce the Islamia University of Bahawalpur.
The Islamia University of Bahawalpur, maybe when they would watch a recording of this session, then our all participants right now and after this session, our KTO Karatai University fellows will know. Islamia University of Bahawalpur is a long decade university and is a progressive university of Pakistan. This university has a number of departments, including the Islamic Finance Department as well. And Islamic Finance Department is a progressive department of the Islamic University of Bahawalpur, Pakistan. We have a journal as well, that is Journal of Contemporary Business and Islamic Finance. And we are in a contract with Global Waqf Conference as well. That is a Malaysian series conference. We are a partner of the same conference series. I think this is enough for today. We should conclude this session and say Allah Hafiz.
Okay, thank you very much, Dr. Uma, and thank you to all the presenters as well as all the participants, especially to Ms. Nuru Saria, Mohammad Zawabi, and Dr. Rasni Hassan. Thank you very much for joining us and giving us an insight about Tawheed and the legal system of Islamic finance that has been followed by Malaysia. It was indeed a very learning experience and an enlightening session. Thank you very much. I also thank KTO Karate University and Karcief conference organizers for giving us this opportunity to interact together and hear the views of such esteemed honorable scholars in Islamic finance. Thank you very much, everyone.
Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh.
Wa alaikum assalam. Allah Hafiz.